Hello again, everyone. This is Lou Assetti speaking as the Blue Ridge Reporter on Saturday evening, March 3rd, 2012, with an interesting story in the Washington Times, at least in its online journal, that appeared today regarding judges in California who are now subject to a new law which went into effect in California, a state law, something called the Judicial Applicant and Appointment Demographic Inclusion Act. How's that for a bureaucratic name? The Judicial Applicant and Appointment Demographic Inclusion Act. Again, effective in California, for California only, its judges in this year, starting January 1. And the purpose of the act is to make sure that homosexuals, lesbians, and transgender persons, so to speak, are represented in the judiciary. That's the purpose of the law, which requires 1,600 judges to complete the application. However, regarding this particular question on the application about the judge's sexual orientation, as the term goes, that is a voluntary response. You don't have to answer that question. According to the Washington Times story, 40% did answer that question. So of that 1,600 potential responders, members of the judiciary in California, 960 did respond. Now, of the respondents, a total of 25 judges said they were either lesbian, homosexuals, or transgenders, and transvestites. And that is a total of 2.7% out of the total of 960 judges. There are a number of things that are interesting about this story. One of them is the statistical amount of 2.7% being either lesbians, homosexuals, or transvestites. Oftentimes, in the past at least, we would hear that a full 10% of the American population would be in that category. And if that were true, then the public opinion about homosexuality may at least be nudged in toward acceptance by people saying, well, you see, they really are, 1 in 10 people is within this category of homosexual activity, broad umbrella category, covering lesbians, homosexuals, of course, and transvestites. But 2.7% of this distilled group of 960 out of 1,600 judges who decided to answer the question. Now, one could say, and I believe this would be speculative regardless of what position one took about this statistical revelation, there may be a number of judges who simply didn't want to say they were in this homosexual category. However, because the question was voluntary, one would think the people who voluntarily answered it would include all those who were willing to admit what they were one way or the other. So it may be that that 2.7% in California among the judiciary is a representation that's fair and accurate, at least to some degree, to the number of homosexuals percentage-wise on the bench in California. Again, one could argue that the other way and say, no, there's a great number who would be ashamed to say what they are. They would be outed, so to speak, and wouldn't want to reveal that. But again, this was a voluntary question. So I tend to think that those who answered it were willing to say what their orientation was, which is why they chose voluntarily to answer the question. And if that's true, then this sense of 10%, 1 in 10 of Americans are homosexual. I would also say the judicial branch may be a category where you would find more homosexuals than in other categories. Again, that's a subjective point of view. Judges being those drawn to books, being scholarly, being part of the intelligentsia, might be more skewed that way than if you took an equal number of construction workers. Again, that's subjective. Of course, I leave that to you to make your own determinations. Another interesting point about this is that this is the result of the popularization, so to speak, to the extent it really is popular, of homosexuality in its practices as a civil right. The American public is coming to believe, some would have us conclude, that this kind of activity is in fact a civil right, part of individual liberty, which has been popularized by Ron Paul. And those who defend Ron Paul say, well, even though we know that it's not a good thing, that homosexuality is approved in the public realm, among those who feel that way, they say, well, don't rest assured, however, Ron Paul's going to be a president if he ever got elected, and because that's a federal position, would have very little to do with the states, even if he were elected, because he'd be so pristinely faithful regarding the Constitution. But I contended that this would popularize this idea, this perverse idea of liberty that's being espoused by Ron Paul, and it would then be would then move into representation on the judicial bench and acceptance by the members of the public, at least to some extent, that judges may be homosexual. And again, people might think, well, regardless of what they may be, they're just going to be objective and call these cases, decide these cases based on objectivity. But that is fantasy. They will use the court system and the law that is as perverse as their practices are to advance their cause. And it's the reason why, in fact, that California has this new Judicial Applicant and Appointment Demographic Inclusion Act to be able to say we need more homosexuals on the bench because we want to create a more representative diversity in California. Interesting story. California, a member of the Union of States, along with other states that are homosexually friendly, so to speak, with civil unions and so-called gay marriages. And it makes you wonder about the other states in the heartland, so to speak, that don't ascribe to this notion. If states with such a fundamentally different view of law and the social order and their fundamental views and worldviews regarding what society and government should be like, do they in fact belong in the same union? That's a question for another day. This is Lou Rossetti speaking as the Blue Ridge Reporter.